Imagine this. You spend 30 or 40 years paying off your home. Every month, every bill, every sacrifice, all of it goes into one dream. One day, this house will be safe. Safe for you. Safe for your partner. Safe for your children. Then one afternoon, someone says, "Why don't you just put the house in the kids' names? That way the tax man can't touch it. The council can't take it, and the family keeps everything." It sounds clever. It sounds simple. It sounds like protection. But in many cases, that one signature can do the exact opposite. It can remove your control, expose your home to your children's problems, fail to reduce inheritance tax, fail to protect you from care fees, and leave your family trapped in a legal mess they never saw coming. So today we're going to break down one of the most dangerous ideas in UK family finance, gifting your house to your children. And more importantly, we'll explain what you should consider instead. Before we continue, please take a moment to like this video and subscribe my channel. It's completely free, and it helps us keep bringing you the important financial stories that matter. Let's get into it. Here is the problem. Most families do not start with bad intentions. They start with fear. Fear that inheritance tax will swallow the family wealth. Fear that care home fees will force the sale of the house. Fear that children will be left with nothing. Fear that the government will take what parents spent their whole life building. And when people are afraid, they look for shortcuts. One of the most popular shortcuts is this: transfer the house to your son or daughter while you are still alive. On paper, it feels brilliant. You no longer own the house. Your children now own it. So surely it is protected. But that is where the trap begins. Because in law and tax, ownership is not just about whose name is on a document. It is also about who benefits, who controls, who lives there, and why the transfer happened. Let's start with the first danger: losing control. When you give your house away, you are not just moving a name on the land registry. You are giving away legal power over the property. That means your child may become the legal owner. And once that happens, your home can become connected to your child's life, not just your life. Their marriage, their divorce, their debts, their business problems, their bankruptcy, their relationship breakdown, their sudden death, their will, their decisions. Think about that for a second. You may trust your child completely. That is not the issue. The issue is that your child's life can change. They could marry someone who later makes a claim. They could run into debt. They could start a business that fails. They could be pressured by a partner. They could pass away before you. They could decide to sell. They could fall out with siblings. And suddenly, the home you thought you had protected is now exposed to risks that were never yours in the first place. This is the part many families do not think about. You are trying to protect the house from the outside world, but by gifting it away, you may be placing it directly into someone else's outside world. That is not protection. That is loss of control. Now let's talk about inheritance tax. Many people believe there is a simple rule: give something away, survive 7 years, and it disappears from your estate. That rule does exist, but it is not as simple as people think. For a genuine gift where you fully give something away and no longer benefit from it, the 7-year rule may apply. But a house is different when you keep living in it. If you give your home to your children but continue living there rent-free, HMRC may treat it as a gift with reservation of benefit. In plain English, that means you gave it away on paper, but you still enjoy the benefit of it. You still live there. You still use it. It is still your home in reality. And because of that, HMRC may still count it as part of your estate for inheritance tax purposes. So what have you achieved? You may have given away control. You may have exposed the property to your child's risks, but you may not have removed it from inheritance tax. That is the cruel part. You can do the paperwork, take the risk, wait years, and still find out that the tax saving you expected never actually existed. Some people then ask, what if I pay rent? That is where things become even more uncomfortable. To avoid a gift with reservation problem, you may need to pay proper market rent to live in the property you used to own. Not a symbolic amount. Not £50 here and there, a real commercial rent, documented properly, paid regularly. But think about the reality of that. You spend decades paying off your mortgage so you can live rent-free in retirement. Then you gift the house to your children and start paying rent to live in your own former home. For many families, that is not practical. It is emotionally painful, financially awkward, and can create new tax consequences for the children receiving the rent. So the simple plan suddenly becomes very complicated. Now let's move to care fees, because this is where many families make the biggest mistake. A lot of homeowners believe that if they give the house away early enough, the local council cannot count it if they later need residential care. But care fee rules are not based on a magic number of years. There is no universal safe date where every transfer becomes invisible. The local authority can look at the facts and ask an important question. Did you give away the asset to avoid paying for care? This is known as deprivation of assets. And if the council believes the answer is yes, they may treat you as though you still own the asset. In other words, you may not own the house anymore, but for the care fee assessment, it may still be counted against you. That is a devastating combination. You no longer control the home, but the council may still assess you as if you had it. Again, you get the risk without the reward. Now, let's make this real. Picture a widow called Margaret. Margaret is 74. She owns a modest house. It is not a mansion, it is the family home. Her husband worked hard. She worked hard. They raised children there. Christmas happened there. Grandchildren learned to walk in the living room. Margaret hears from a neighbor that she should sign the house over to her two children. The neighbor says, everyone does it, it protects the house. Margaret does not want to be a burden. She does not want the government taking what belongs to the family. So she signs the property over. At first, nothing changes. She still lives there. Same sofa, same garden, same kettle, same Sunday visits. But legally, everything has changed. A few years later, one child gets divorced. Their share of the house becomes part of a financial argument. The other child has money problems. Creditors start looking at assets. Margaret wants to downsize, but now she needs agreement. Then her health declines, and the family applies for care support. The council asks why the property was transferred. The timing, the motivation, and the circumstances are reviewed. Suddenly, Margaret realizes something heartbreaking. She gave away the house to protect her family. But now the family is arguing, the house is exposed, and the authorities may still treat the transfer as if it never protected her. Nobody planned for that. Nobody wanted that. But it happens because the family confused paperwork with protection. This is the key message of the whole video. A home is not just an asset. It is control, security, shelter, dignity, and bargaining power. Do not give that away casually. Now, does this mean you can never help your children? No. Does it mean all gifting is bad? No. Does it mean estate planning is impossible? Absolutely not. It means the plan has to match the problem. And before you do anything dramatic with your house, you need to ask 5 questions. Question 1. Do you actually have an inheritance tax problem? Many people panic before they calculate. Inheritance tax depends on your estate value, your allowances, your marital status, whether you leave a home to direct descendants, and whether unused allowances can transfer between spouses or civil partners. Some families assume they face a huge bill when they may not. Others do have a problem, but the house transfer is still not the right solution. So the first step is not signing anything. The first step is adding everything up: your home, savings, investments, pensions, life insurance, debts, expected growth. Then compare that with the available allowances. Only after that can you know whether there is actually a tax issue to solve. Question 2. Do you have a valid will? This sounds basic, but it is where many families fail. A will is not exciting. It is not a clever loophole. It does not sound like a viral tax trick. But it is one of the most important documents your family can have. Without a proper will, your estate may not pass the way you expect. That can create delays, arguments, unnecessary stress, and sometimes serious unfairness. If you want your children protected, start with a document designed to say who gets what. Question 3. Do you have lasting powers of attorney? This may be even more urgent than inheritance tax. If you lose mental capacity and nobody has legal authority to manage your affairs, your family may need to apply through the court of protection. That can be slow, expensive, and stressful. A lasting power of attorney for property and financial affairs can allow trusted people to manage money, bills, property, and decisions if you cannot. A health and welfare LPA can help with medical and care decisions. Families often worry about what happens after death while ignoring what happens if someone becomes vulnerable while still alive. That is a huge mistake. Good planning protects you during life, not just your beneficiaries after death. Question 4. Are you gifting what you can genuinely afford to lose? This is where sensible gifting can work. Gifting spare cash may be very different from gifting the roof over your head. If you have surplus income, you may be able to make regular gifts without reducing your own standard of living. If you have savings beyond what you reasonably need, you may choose to help children or grandchildren earlier. But the key phrase is this: genuinely afford to lose. If giving something away leaves you dependent, anxious, or unable to adapt, it is not planning. It is self-sabotage. A good gift should not make your own life fragile. Question 5. Are you trying to keep the benefit while giving away the ownership? This is the danger test. If the answer is yes, stop. If you want the house to be not yours for tax and care fees, but still yours for living, control, comfort, and security, you are trying to have it both ways. And the rules are designed to challenge exactly that. Real planning involves real trade-offs. You can give something away, or you can keep control. But pretending to do both is where families get hurt. So what should you consider instead? First, get proper advice before signing anything. Not advice from a neighbor, not a social media comment, not a 5-minute conversation with someone who heard something from a friend. You need advice from a qualified solicitor, tax advisor, or financial planner who understands your full situation. Second, build the basics. A will, lasting powers of attorney, a clear record of assets, beneficiary nominations, a plan for pensions, a conversation with your family. These boring steps prevent more disasters than any clever trick. Third, use legitimate gifting carefully. Small annual gifts, wedding gifts, regular gifts from surplus income, early support for children where affordable. These can be part of a sensible estate plan, but they should be documented properly and should not leave you short of money. Fourth, review pensions. The rules around pensions and inheritance tax are changing from April 2027, so families who previously treated pensions as outside the estate may need to rethink. That does not mean everyone should rush to withdraw money. It means the old assumption may no longer work for everyone. For some people, spending from pension funds during life may become more sensible. For others, it may not. This is exactly where personal advice matters. Fifth, consider trusts only for the right reasons. Trusts can be useful. They can help with control, blended families, vulnerable beneficiaries, second marriages, children who are not ready to inherit, and protection from certain family disputes. But a trust is not magic. Putting your house into a trust while continuing to live in it may still create tax problems. Trusts also cost money, require administration, and need proper legal advice. So do not buy a trust because someone sells it as a miracle solution. Use it only if it solves a real problem in your family. Here's the simplest way to think about it. Bad planning asks, how do I hide the house? Good planning asks, how do I protect my security, reduce unnecessary tax, and pass wealth on safely? Those are very different questions. One is fear-based, the other is strategy-based, and fear is where families make expensive mistakes. Now there is another emotional part of this that people rarely say out loud. Parents often gift the house because they love their children. They want to help. They want to make life easier. They want to stop conflict after they are gone. But sometimes the best gift you can give your children is not the house early. It is clarity. A proper will, a written plan, no surprise documents, no unclear promises, no arguments between siblings, no sudden discovery that the home was transferred years ago and now belongs to one person more than another. Because inheritance disputes are not always about greed. Often they are about confusion. One child says, "Mom promised me this." Another says, "Dad wanted it split equally." Another says, "But I looked after them." Another says, "But my name is on the house." And what began as love becomes resentment. A good estate plan should reduce confusion, not create more of it. That is why signing over the house is such a dangerous shortcut. It feels like a clean solution, but it can create more questions than it answers. Who pays for repairs? Who pays insurance? What happens if one child wants to sell? What happens if one child dies? What happens if a child divorces? What happens if you need to move? What happens if you fall out? What happens if tax rules change? What happens if the council disagrees? Most families never ask these questions until something goes wrong. Ask them before you sign. So let's bring everything together. Never gift your house to your children casually. Not because your children are bad, not because planning is wrong, not because the government always wins, but because your home is usually the most important financial and emotional asset you have. It gives you shelter. It gives you independence. It gives you choices. And in later life, choices matter. The ability to sell, downsize, release money, move closer to family, adapt the home, pay for care, or simply sleep at night knowing you are secure, that is worth protecting. A rushed transfer can take those choices away, and once they are gone, getting them back may be difficult, expensive, or impossible. So before you gift the family home, do this instead. Calculate whether inheritance tax is actually likely, make or update your will, set up lasting powers of attorney, review your pension and beneficiary arrangements, use affordable gifting properly, document your reasons, talk to your family, get regulated professional advice, and only consider more complex structures if your situation genuinely needs them. The family home should not be moved around like a chess piece because someone online said it saves tax. This is your life, your security, your children's future, your dignity. Treat it with the seriousness it deserves. And remember this final rule. If a plan only works because nobody asks questions, it is not a plan. It is a gamble. And your home is too important to gamble with. If this video helped you understand the risk, please like the video, subscribe to Britain Daily, and share it with someone who is thinking about signing their home over to the children. It could save them from a decision they cannot easily undo. And as always, this is general information, not personal financial or legal advice. Rules can change and your circumstances matter. Before making any decision about your home, inheritance tax, care fees, trusts, or pensions, speak to a qualified professional, because the goal is not just to pass something on. The goal is to pass it on safely.